Hello, everyone. Good morning, good afternoon, or good evening, depending on where you're joining us from today. A very warm welcome from me. For those of you who have not joined us before and don't know me yet, I'm Enherad Lang. I'm the Executive Director of PHAP, that's short for the International Association of Professionals in Humanitarian Assistance and Protection, and very pleased to be serving as your host today in this first online briefing of the fall. So thanks very much to all of you for joining us. I'd like to mention before we get going that this event, this online briefing, is organized as part of the Geneva Humanitarian Connector, an initiative of PHAP supported by the Swiss Federal Department of Foreign Affairs, designed to strengthen dynamic connections between humanitarian actors in Geneva and between Geneva and the rest of the world. So thanks for being a part of this. So now we'll get into the substance of today's event entitled IHL at Sea, Key Findings from the Updated ICRC Commentary on the Second Geneva Convention. We're going to be exploring today the legal implications of the Second Geneva Convention, dealing with protection of wounded, sick, and shipwrecked in armed conflicts at sea. And although this convention may be a bit less familiar to some humanitarian practitioners and some of you on the line compared with other of the Geneva Conventions, it is certainly relevant to a lot of people working in the sector, including, for example, related to rules related to hospital ships and coastal rescue crafts. And today our guest expert, Bruno de Meyer, will be presenting key findings from the recently updated commentary by the ICRC on the Second Geneva Convention. So with that, very pleased to welcome once again as a guest expert speaker, Bruno de Meyer, who's legal advisor with the ICRC's legal division in Geneva, where he is part of the team updating the ICRC commentaries on all the 1949 Geneva Conventions and their 1977 additional protocols. Bruno played a leading role in terms of coordinating the updated commentary on the Second Geneva Convention, on which we will focus today. I would also like to mention that Bruno was in fact one of the founding members of PHAP, so it's particularly nice to have him with us here in the office once again. So welcome, Bruno. And now, without further ado, I will hand over the virtual floor over to you.
Thank you very much, Enherad, and good afternoon, good morning, and good evening to everybody dialing in from around the world. It's a great honor and pleasure for me to be able to speak about the work I, along with many others from around the world, have been involved in for the last more or less 4 years. The picture you have up there, my first slide, is a picture of 2 hospital ships. One, the one closest to us, is a Chinese hospital ship called the PHAP, and the other is one of the 2 American hospital ships. And we'll be speaking about the IHL aspects regulating that particular category of vessel in further detail down the road during my presentation. Now, the reason why I wanted to put that slide up first is to emphasize what specifically the Second Geneva does and Geneva Convention does and does not deal with. Because generally, when speaking about international humanitarian law regulating armed conflicts at sea, a great amount of attention and expertise gets devoted to aspects related to the conduct of hostilities, as well as to aspects related to means and methods of warfare that are peculiar and specific to naval warfare. Topics like naval mines, topics like a naval blockade, etc. Now, these are all topics that are regulated in different conventions as well as in rules of customary law. But where the Second Geneva Convention kicks in and becomes relevant is after we have had a particular attack, say with a torpedo against a warship, which as a matter of international humanitarian law is obviously in principle a perfectly lawful attack. At that very moment, the flip side of the law of armed conflict comes into play. And this is the protective side of the law. And it's at that very juncture that the Second Geneva Convention becomes relevant, because this convention deals with the protection of members of the armed forces. So we're dealing with combatants who, once they qualify as a matter of law as being wounded, sick, or shipwrecked, as well as, I should emphasize, dead, we'll get to that topic later on, are deserving of certain elements of protection, and the enemy needs to take certain measures in order to try to rescue them from their perilous situation. Now, obviously, I know that a lot of you are familiar with the Geneva Conventions as well as with their additional protocol. I won't hold it against anybody if this is the first time you have the opportunity to really go into the Second Geneva Convention, because this convention has always been considered the most technical, one could almost say the most obscure of the four Geneva Convention, and few people, including those we now worked with as part of this project over the last few years, ever considered themselves really an expert in the convention until we at the ICRC launched this initiative to update the commentaries on the four Geneva Convention. It's our sincere hope that by having done this process and by having published a couple of months ago the updated commentary on the second convention, we have managed to demystify this perception that the second convention is difficult. Yes, I'll explain. There are some technical rules in there on particular categories of vessels, but by and large, the core message embedded in the convention is no different from the core message which underpins IHL as a whole, which is that an enemy, once out of combat, once wounded, sick, or shipwrecked, whether on land or at sea, is no longer an enemy, is no longer a lawful target, but is a person whom the law compels to be conferring protection on. Before going into the substance of the convention, I just wanted to briefly situate the project to update the ICSC commentaries on the Geneva Conventions. When the Geneva Conventions were adopted in 1949, in the decade thereafter, the ICRC published its own article-by-article commentary on each of the four conventions. And these commentaries, which remain on the ICSC website, basically give you an overview of the background of every single treaty provision. What was the humanitarian problem governments wanted to address? Were there, during the 4 years of negotiation of the convention, were there any diverging views or competing drafting proposals? And why were particular words chosen rather than others? Now, obviously, what these commentaries couldn't do was anticipate what would happen in practice with the convention. Was the convention a fair answer to a particular problem? Or did some of the wording give rise to uncertainties and therefore over time the potential for diverging views? It's in light of that, along with other reasons, that the ICRC decided some 7 years ago that time had come to update the commentaries to all four conventions. On the slide I've put on there details in the introduction on our commentary, which is available online on the ICSC website. This slide basically intends to demonstrate that this is not a process by which we go quickly. There's various layers of review, of analysis, and of many, and this I really should stress, many people from around the world who have an opportunity to contribute and to criticize our findings prior to publication. So obviously, like all research, it starts with research into military manuals as well as battlefield practice, state practice, which in the case of law of naval warfare obviously raises a more difficult methodological questions, because contrary to the situation before the Second World War, we have seen relatively little armed conflict at sea since 1949. There have been a couple, including a couple of armed conflicts in which the Second Convention was clearly called upon to play a role, but it is a fact that there have been relatively few true armed conflicts at sea to which IHL, including the Second Geneva Convention, was applicable. So therefore, we also turned to scholarly publications, including the San Remo manual regulating international law applicable to armed conflicts at sea, dating from the mid-1990s. Now, once that research has been done, and we really look at every single conventions per article by article as well as paragraph by paragraph to try to get an understanding of where did this come from, what has happened in the decades since 1949, drafts get circulated, first to all the authors that are contributing to a particular convention, and then to an editorial committee of very senior and very, I would say, well-established and famous people in terms of international humanitarian law. They get an opportunity to contribute and to provide their views on the draft, which we take into account. And then the final, and I would say most interesting step, is the manuscript. Once we think we're ready, the manuscript gets circulated to a worldwide group of peer reviewers. Now, peer reviewers act in their private capacity. It's not a formal consultation of the high contracting parties, but peer reviewers have been chosen in view of their seniority, in view of their expertise for the subject matter at hand. And that group of peer reviewers is different per convention. For this convention, we were privileged to have around 45 peer reviewers, including many of them of which have had extensive naval as well as naval legal experience serving in the navies of their particular country, which obviously we hope their insights and sometimes critique to the draft we circulated to the greatest extent possible has been taken on board, and we hope will improve both the user friendliness as well as the legitimacy of the final publication. So the commentaries are available both online for free on the ICRC website. There's also opportunity to purchase a paper version published by Cambridge University Press. This to give you an overview of the timing. So about a year and a half ago, the ICSC published its updated commentary on the first Geneva Convention, which deals with the same topic as the one we're dealing with today, protection of wounded and sick armed forces, but in land warfare. The second convention we published in May of this year. And now our project is back into the research and drafting phase for the third convention, a long convention, dealing with the protection of prisoners of war. So members of armed forces who, one way or another, fall into the hands of the enemy. Further down the road, in a couple of years from now, we will publish the updated commentary on the fourth convention, dealing with a topic of utmost importance also for humanitarian professionals, being the protection of civilians in time of armed conflict. And you have the timeline there in terms of how quickly we intend to be able to produce the new commentaries, but as I think was obvious from the chart I put up there with the various steps that are undertaken, there's a lot of rigor that we invest in making sure that we get input by knowledgeable people from around the world. We don't want to rush and publish something only to find out that there's shortcomings in the publication. Without further ado, I want us to now look really at the question of when does IHL apply at sea? Because obviously, and I assume many of you are familiar with the question that obviously that often obsesses lawyers that are dealing with international humanitarian law. It's the question of when do we have an armed conflict? Because situations remaining below the threshold of an armed conflict, as violent as they may sometimes appear to be, are not regulated by international humanitarian law. They're regulated exclusively by other legal frameworks, but international humanitarian law only applies once we have crossed that threshold of an armed conflict. Now, without being able to go into all the details, which you'll find in the commentary on Common Articles 2 and 3, we've had to devote quite some attention to the question of what's the distinction between various operations in the course of which states do use force at sea versus a genuine armed conflict at sea. And what I'm referring to here are maritime security operations. Now, maritime security operations, which has the last few years really become a buzz term encompassing a wide variety of actions. It's states that are dealing with the threat of piracy, with illicit drug trafficking at sea, with response to migration phenomena at sea, are a wide variety of activities to which states, be it through their Navy and or Coast Guard, deal with certain phenomena at sea. Now, the starting point there is that as a matter of international law, when a state wants to enforce certain of the legal frameworks that are applicable to these phenomena at sea, force may be used. One example, easy to understand, is that states, a coastal state, will be able to enforce its domestic fisheries legislation at sea, for example, against a vessel violating that domestic fisheries legislation. And force may be used in order to make sure that the vessel that is suspected of violating that regulation, that it stops, and that the individuals on board may be arrested eventually with a view to being handed over for prosecution and trial, etc. Now, the difficulty we had to grapple with is, if you look at traditional understanding among IHL lawyers of what an armed conflict is, the threshold in particular for international armed conflict is quite low. It's any use of force between states. Now, if we were to apply that definition to maritime security operations, we would end up with the wrong result, that maritime security operations would be regulated by IHL, which is not the case, because there's a general understanding that, for example, the fight against piracy is not a phenomenon that is being regulated by the law of armed conflict, because it is not an armed conflict. So the paragraph I've put up there, and you can read it after the presentation to go into all the details as well as the context in which it appears in the commentary, really tries to flesh out that we are going to observe in the maritime domain states using force in order to enforce domestic legislation, or in order to deal with certain phenomena, but that these in principle will not be regulated by the law of armed conflict. Where obviously we've had to leave the question open is that we may see that in certain instances states use force not inspired, not motivated by a desire to enforce their domestic security legislation, but motivated by other considerations. Now, state practice itself, in particular in military manuals, hasn't really grappled with this question, and so the jury is still open if in the years ahead we are going to see certain incidents that come close to the threshold of an armed conflict. In the last few years, we have seen a number of these incidents where really the question may be asked: state vessels from two states are engaged in standoff situation. It gets violent, engines get destroyed, maybe even people get injured. From what moment on do we have an armed conflict, to which the law of armed conflict, also called IHL, applies? Now, what's critical there is to make sure not to over nor underextend the applicability of IHL. In other words, we, especially from the ICRC perspective, really want to make sure that from the moment it becomes relevant, meaning the facts on the ground, in this case at sea, are of such a nature that they would qualify as an armed conflict on land, that they also qualify as an armed conflict at sea. And this obviously will be inspired by protection considerations. Are people injured? Are people wounded? Or have people been detained? But this obviously, the question of the interplay between violent incidents at sea versus an armed conflict where we've crossed the threshold remains a difficult one. It's also one where, except a recent article in the ICRC's review dealing with war and security at sea, which has just been published by the international community of the Red Cross, there's one article there dealing with this interplay between incidents at sea and armed conflict. But there's a lot of open questions that we identified, but were clearly the jury is still out in terms of how will states eventually themselves consider whether they're below or beyond the threshold of an armed conflict. Moving on, going really now into the nuts and bolts of the second Geneva Convention, I want to give an overview in a nutshell of who, what, and where is protected under this convention. So the starting point is that, except Common Article 3, which I'll get back to in a second, the convention as a whole, as such, only applies to international armed conflict, so conflict between two or more states, and it protects, in terms of personal scope of protection, it protects members of the armed forces once they are wounded, sick, or shipwrecked at sea, or once they are dead. It's a point we'll get back to later on. The title of the convention only speaks of wounded, sick, and shipwrecked, but there's a number of important provisions in the convention dealing with the protection of the dead at sea. What's important to underline is that the criteria to be covered by this convention is being a member of the armed forces. So it's not only members of the Navy. A person who's a member of the Air Force, yet who becomes wounded, sick, or shipwrecked at sea, will equally be protected by the second convention, just like a person who's a member of the Navy, but who becomes wounded on land, will be protected by the first convention. So the criteria in terms of scope of application really is a geographic one. Where is the person being wounded, sick, or shipwrecked? Now, the only point which was difficult to deal with in terms of personal scope of application is that on the basis of Article 13, there are certain individuals who are civilians, yet who have a close link to the armed forces, are equally protected under the convention. These are, for example, persons accompanying the armed forces who in certain cases may equally be protected by the second convention and may equally become prisoners of war in case of their falling into enemy hands. Now, the gap there in the convention, which we could only note without solving, is that these individuals are only protected to the extent they're enemy. So, for example, members of a crew of an enemy merchant vessel may be protected under this convention, but there's no protection under the second convention for neutral crews and neutral vessels. And this is unfortunate in view of the fact that under the law of naval warfare, neutral vessels, to the extent their activities bring them in too close a proximity to the warfighting effort of a party to the conflict, may qualify, depending on the circumstances, as a military objective. Going on to Common Article 3, so this is the so-called mini convention regulating non-international armed conflict. The scope of application of that convention is obviously wider because it protects not only in case of a non-international armed conflict, it protects not only members of the armed forces, but it also protects members of the organized armed groups that are fighting the government, as well as civilians. To the extent all of these groups that I refer to qualify as being wounded, sick, and shipwrecked in the sense of IHL. Now, a very important point also for a lot of you who are practitioners is the question of, so does the second Geneva Convention protect migrants who become shipwrecked at sea, whether we have seen in recent years in the Mediterranean as well as in other parts of the world. And here it's important to distinguish between various scenarios. The first scenario is a person who flees an armed conflict, ends up further down the road in his or her migration path. And we're not talking here about legal labels, whether qualifying as a refugee, an IDP, a migrant, etc. We're speaking generically about persons fleeing an armed conflict. At some point in the trajectory, they end up embarking upon a vessel, and that vessel sinks. Now, these individuals are shipwrecked in the common sense of the term, in the layperson sense of the term, but they are not shipwrecked in the sense of the Second Geneva Convention, nor in the sense of IHL. The reason being is that their being shipwrecked is not a direct result of the hostilities. So the other scenario where we do have individuals that qualify as being shipwrecked in the sense of IHL would be a vessel carrying migrants, and that vessel gets attacked by a party to an pre-existing, ongoing, non-international armed conflict. These people have become shipwrecked as a direct result of the hostilities, of the fighting, and therefore are legally entitled to the protection as being shipwrecked. So this is an important point to be clear about the scope of the term shipwrecked as used by international humanitarian law. Now, the question of are civilian shipwrecked protected by international humanitarian law? The answer is yes, but not by the second convention, because this is exactly what the fourth convention will be dealing with. In that convention, where we haven't written the updated commentary on yet, but it does contain a number of provisions which explicitly refer to the protection of civilians who are wounded, sick, or shipwrecked at sea. Further point, which you'll find in the commentary on Article 12, is who exactly is shipwrecked. And there, interestingly, the contours are uncertain once you go beyond the cases everybody agrees upon, which is persons who are physically in the water as a result of the hostilities, who are in life raft, etc. Questions have been raised in the literature as well as in military manuals, whether people can qualify as being shipwrecked when being on board a warship that has lost its entire capability to function, or when the vessel has run aground. But there we found certain indications in the literature. This is definitely an area worthy of exploration, both by scholars as well as by states themselves. We found a couple of rules in the convention, articles 14 and 18, which deal with the protection of wounded, sick, and shipwrecked, yet with no recent practice. Article 14 is the century-old right of a warship when it encounters a vessel carrying wounded, sick, and shipwrecked at sea, the right to demand that these people be surrendered to the warship on the condition that they can safely be moved and that the vessel has the capability to medically treat them. This is something, when discussing with military operators, there was an almost general consensus that this is something that hasn't happened in the last few decades, and it's quite unlikely to happen in the near future, because why would you want to burden yourself with the obligation to look after the medical needs of these people? Be that as it may, the provision remains valid and may be called upon in case of an armed conflict at sea. A second example, Article 28, deals with the hypothesis of hand-to-hand fighting on board a warship. And they're well-informed historians of naval warfare explain to us that the last time this happened was over 200 years ago. Be that as it may, the provision remains relevant and valid as a matter of international humanitarian law. Finally, dealing with the protection of wounded, sick, and shipwrecked, the convention also contains a number of provisions, difficult provisions, dealing with the hypothesis that the persons protected by the Second Geneva Convention end up, one way or another, in the hands of a neutral power. This is the hypothesis whether they being rescued have been picked up by a neutral warship or a neutral military aircraft, as well as the hypothesis that these people, one way or another, reach a neutral port. And what the Second Convention grapples with is the question of whether, under the law of neutrality, the neutral power has the obligation to intern these people, to guard them in a way that they can no longer go back to the hostilities. Now, the language chosen by the drafters of the convention is to not actually answer the question, but to indicate that the neutral power needs to do this were so required by international law. So the substantive rule remains outside of the Geneva Conventions, and the drafters were extremely uncomfortable to have a discussion on the precise contours of the law of neutrality on this very point. Now, for those interested in biting your teeth in a very technical commentary, I'd recommend the commentaries on Article 15 and 17, where the state practice went in all possible directions, both in favor and against neutral powers interning wounded, sick, and shipwrecked, which end up in their hands. And it seems that what the drafters of the Geneva Convention wanted is actually still the law. In other words, the neutral power retains the entire discretion, entire freedom of interpretation to decide whether to intern or not. A final point on scope has to do with the geographic scope of protection under the convention. The title of this convention says at sea. There's no definition of this concept in the Second Geneva Convention, and obviously, since the decades after 1949, there has been, particularly since the UN Convention on the Law of the Sea in 1982, a much more sophisticated understanding of how our world's oceans are being divided, high seas being only one of them. Now, one of the questions we've had to grapple with is, where does the convention apply in terms of geographic scope of application? Does it apply beyond saltwater sea? Can it also apply to armed conflicts that take place on lakes as well as on rivers? Now, these are not academic questions. There have been, in the course of history, including in recent history, certain armed conflicts where hostilities were conducted on lakes as well as on rivers. Long story short is that the position we have adopted on this particular question is to argue that when it comes to the question of who deserves the protection of the Second Geneva Convention, the legal status of the water in which the person is found is immaterial. The protection needs of a person are going to be identical whether on the high seas or whether on a river, in a river or on a lake. The support we have for that position is Additional Protocol 1, which in Article 8b, when defining who is shipwrecked, already refers to the notion of at sea or in other bodies of water. So in our commentary, Article 12, you will find an extensive analysis of the fact that yes, the ICRC is aware of the fact that under UNCLOS the sea is divided into various zones where states have various passage rights and jurisdictional entitlements. But when it comes to the question of who deserves to be protected under this convention, the protection needs are identical regardless of the legal status of the water in which the person is found. And now we go into the topic which is obviously the most esoteric one of the entire convention, hospital ships. Now, hospital ships play a big role in the Second Geneva Convention. There's over 10 articles exclusively dealing with this category of vessels. Let's take a look first and foremost at the definition. Article 22 speaks of ships that have been built or equipped. So it's the two hypotheses. Either you built a ship from the beginning as a hospital ship, or you transform, you convert another type of vessel into a hospital ship by the powers. So these are vessels controlled by the state, by the military. This is why they're referred to as military hospital ships. And then comes the crux of the definition, which is built or equipped specially and solely with a view to assisting, treating, and transporting wounded, sick, or shipwrecked. Now, this puts the bar very high. It means that the only activity, the only functionality of this vessel must be and can be to look after the medical and transport needs of persons protected by the Second Geneva Convention. In other words, a lot of states' navies have vessels that are so-called multimodal vessels, which have various capabilities, including a medical capability. These vessels do not qualify for the special or the specific protection as hospital ships under the Second Geneva Convention. As a matter of fact, nowadays, there's only, and we had a worldwide survey on this question, nowadays there's only 3 states in respect of which unequivocally one can reach the conclusion that they possess and operate permanent military hospital ships, and these are the People's Republic of China, Russian Federation, as well as the United States of America. Now, I won't be able, for reasons of time, to go into all the very technical rules regarding hospital ships. I just wanted to identify 3 topics of interest. One is Article 31, which quite surprisingly, at first sight at least, deals with quite extensive, quite far-reaching entitlements of a party to a conflict to control, to search, to inspect, even to detain for a period of up to 7 days under certain circumstances, an enemy's military hospital ship. Now, the irony is obvious. On the one hand, the convention confers the most extreme, most complete form of protection to hospital ships. On the other hand, the enemy has quite intrusive entitlements to inspect this vessel. Why? It has everything to do with the mindset of the drafters of the Geneva Convention when it comes to the topic of hospital ship, and that's a mindset of distrust. In the course of history, hospital ships before the Second World War as well as during it, hospital ships have been abused for purposes unrelated to the hostilities, have been used and abused for so-called acts harmful to the enemy. Because the question always is, our enemy claims that this vessel is to be protected as a hospital ship. Can we really trust that in actual practice what's going on thanks to this vessel is not, say, transport of able-bodied combatants? A second point, which was interesting also from a methodological perspective in terms of development of the law, was Article 34, paragraph 2, which as one of the examples of what may qualify as an act harmful to the enemy, leading to a loss of protection under the convention, refers to this notion that hospital ships may not possess or use a secret code for their communication. I'm not able, for reasons of time, to go into all the details, but the long story short on this commentary is that it's been argued by a number of naval powers that in view of technology, satellites, it is, as a matter of contemporary technology, no longer possible to comply with this rule. A final point which the commentary had to deal with when it comes to hospital ships is loss of protection because of certain arms being mounted on it. And this, our commentary on Article 35, goes in great detail in all the controversies and debates there have been over the last few years, because the traditional understanding of IHL, as supported by the ICRC, is to say that vessels or transports on land or hospitals, yes, you may mount certain weapons on it, but only so-called deflective means of defense, so to deflect an incoming attack, as well as so-called light individual weapons. Anything going beyond those categories are, in principle, you may not mount them on the medical facility while being entitled to continue to display the distinctive emblem of the Geneva Convention. For the ICSC, there's no problem as such to go beyond these categories of arms. The only restriction that flows immediately from it is that once you arm your hospital ship with weapons that are not deflective, that are not light individual weapons, you lose, in principle, the entitlement to display the emblem. But this is a question on which a number of states have expressed diverging views, and we, in our commentary on this as on other topics, do reflect these diverging views in the commentary. Moving on, coastal rescue craft. Now, whereas there's over 10 provisions in the second convention dealing with hospital ships, which nowadays only 3 states possess, there's obviously always the possibility for a state at the outbreak of an armed conflict to transform a vessel into a hospital ship. One of the interesting observations here when it comes to coastal rescue craft is that this is something that almost all states with access to a coast or a lake or rivers, they will have one way or another to deal with the rescue of people in distress at sea or in other bodies of water. The irony is that only one provision in the entire convention deals with these craft. And it was also during the negotiation of the convention, this was one of the more difficult, controversial ones, where certain states were not ready to confer protection to these coastal rescue craft for the same reason as the one I highlighted for hospital ships: distrust. Who are the individuals engaged in these activities, and can we trust them to be genuinely humanitarian, or is there a risk that they are claiming to be carrying out certain humanitarian activities, whereas in actual practice, what they're really doing are intelligence gathering, espionage activities? Now, what the convention says on this particular point is that they are to be respected, and small craft employed by the state or by officially recognized lifeboat institutions, so non-state entities, but recognized by the state to carry out coastal rescue operation, they need to be respected and protected under the same conditions as hospital ships. So it means you cannot attack, you cannot capture. But the devil is in the final end of the provision, which ends in paragraph 1 of Article 27 with the notion of so far as operational requirements permit, which obviously is a fairly flexible, fairly loose terminology, which allows to a commander under certain circumstances to decide not to grant the same extent of protection as would be required under when it comes to hospital ships. So the background, as I indicated, was also there, like the issue of distrust. In our commentary on Article 27, you will find the findings of our work regarding a survey to map out the legal nature of entities at the domestic level carrying out search and rescue activities. And there's only one term that can actually describe the situation worldwide. It's the word of diversity. States have really decided to deal with these activities in a very diverse way. In certain countries, it's the military, the armed forces. In other states, these activities are undertaken by state organs, but that are civilian in nature. And in other countries, it's private organizations, whether the Red Cross or Red Crescent Society, or whether a private association that has a contract with the state, or people that do this entirely on a volunteer basis. Two final points that I wanted to highlight here is that obviously this language of so far as operational requirements permit, which dates from 1949, nowadays has to be read together with the rules that are in the protocol or the customary equivalent thereof when it comes to the conduct of hostility. So obviously you may only decide to direct an attack against the coastal rescue craft to the extent that it meets, in the circumstances ruling at the time, the requirements to qualify as a military objective. Of note also is that since 1949, there have been a number of diplomatic initiatives undertaken to try to enhance the protection as embedded in Article 27. All of these initiatives have failed. The protocol has only on one technical procedural point introduced a change, but it's by and large it seems that certain countries are not ready to go beyond the protection conferred on the basis of Article 27. And now we'll deal with what is the most important and also sensitive provision of the entire convention. It's the one provision, Article 18, that actually requires parties to the convention, because the general logic of the convention is that members of the armed forces, once they're wounded, sick, or shipwrecked, are to be respected and protection. Now that's a statement of principle. That's a lofty notion. It's a legal obligation, Article 12. But the way how this is operationalized, you find in Article 18. And this provision indicates that after each engagement, parties to the conflict shall, so it's a legal obligation, take all possible measures to search for and collect the casualties as well as the death of the engagement. Now, this is obviously the one provision where I believe from the perspective of those monitoring the implementation of the law of armed conflict, where attention should go. It's also the difficulty, I'll get back to it in the final part of my presentation, of monitoring the implementation of IHL at sea, because contrary to, say, situation of urban warfare, it's much less likely that independent observers will be able to monitor implementation of IHL at sea. The other reason why this provision obviously is so important is because it requires commanders to make the very difficult judgment calls as to what the so-called possible measures are under the circumstances. A couple of points. I'm not able to summarize the entire commentary on Article 18. What's the end of the engagement? And the end of the engagement, we found no authoritative definition. We clearly identified a risk that some would try to argue that the end of the engagement was the end of the armed conflict, which obviously, if that's the interpretation, there's not much protection left on the basis of the second convention. And therefore, on the basis of parallel rules in the protocol, the position now adopted has been to indicate that the engagement has ended whenever circumstances permit. In other words, it requires a good faith assessment from the parties to the conflict as to what is possible in any given circumstance. The obligation applies to the parties to the conflict. Now, there's an important balance that had to be struck here between this being an obligation applicable to the party to the conflict, so the state, versus the obligation of an individual commander. To what extent is an individual commander that was the one who actually caused the casualties, is that commander personally liable for undertaking all possible measures? A key topic which runs throughout the commentary on this provision has to do with the role of submarines. Are submarines, to the extent they have the possibility to do and to undertake some of these measures, are they legally compelled to take these measures or not? Very sensitive question. Finally, the convention speaks about taking all possible measures. And I've reached the conclusion after now having spent a lot of time on this convention that the most important word in the entire convention is the word possible. It's obviously a notion that is prone to abuse, to an extensive interpretation that ends up hollowing out the protection to the extent of it becoming meaningless. In our commentary on Article 18, you'll find what we identified was the way in which military manuals have dealt with this notion of what is possible, what is impossible, and you find arguments going, broadly speaking, in two directions. One is impossibility being defined as a logistical, a practical impossibility. Put bluntly, there's 200 casualties in the water. I have a vessel that can only take on board 20. Obviously, it's impossible to rescue anybody, but maybe it's possible to take other measures to make sure that these individuals you cannot take on board can survive while bigger craft are able to make it to the sea. And the second, obviously more slippery, potentially more dangerous type of interpretation is possibility being interpreted as security and military considerations, with again the looming threat of to what extent does our enemy still have submarines out there that make it dangerous for us to carry out the activities contemplated on the basis of Article 18. There's a couple of interesting topics we had to deal with when it comes to the dead, which are equally protected on the basis of the Second Convention. First were changes in technology between 1949 and nowadays, where clearly the technology that is available nowadays does allow to retrieve dead bodies even in quite significant period of time after the engagement has ended, as well as, and you'll see this reflected in our commentary on Article 18, a much more sophisticated understanding from the side of forensic expert, forensic anthropologist, when it comes to the science of marine taphonomy, the science of studying how dead bodies decompose over time at sea. Now, these elements of both technology and of scientific knowledge raise the question of what's their impact on the interpretation of this convention. And one of the difficulties there was obviously to what extent can it be argued that if it's possible to do so, you have to do so. A final point, which I'll only highlight here because the law is unsettled, is what's the relationship between your obligation on the basis of Article 18 versus the status of a sunken warship during an armed conflict, which at face value should be considered booty of war. It's enemy movable property. So in principle, as far as the relationship between the parties to the conflict are concerned, you are entitled to take it and consider it yours. Now, the difficulty there, and this is where the law is currently unsettled in terms of precise contours, is that to the extent inside the warship you have human remains of, say, soldiers who were trapped inside, these human remains qualify and need to be respected as a maritime war grave, meaning you cannot just take this vessel without running the risk of interfering with the respect that needs to be given to the maritime war grave. Final point, we can go into Article 21. I just wanted to highlight there because it allows for the possibility for parties to the conflict to appeal to the charity of neutral vessels in order to come to the rescue. This brings me to the final point, and probably one of the more fascinating points for legal scholars. What's the relationship between the convention as adopted in 1949 and other bodies of international law that have been adopted in the decades since, regulating activities at sea? A first one is the 1982 UN Convention on the Law of the Sea, which as such remains in operation in time of armed conflict. It's possible, however, to suspend certain rules on a provision by provision basis because of the armed conflict. One of the interesting things there is that sometimes concepts defined in UNCLOS were useful for the interpretation of the Second Convention. The most prominent example there is the term of warship, which is used throughout the Second Geneva Convention without any definition. Article 29 of the UN Convention on the Law of the Sea provides a definition of what's a warship, and everybody was agreed that the way we nowadays need to interpret the term warship as used in the Second Convention is based upon the definition provided in the UN Convention on the Law of the Sea. Finally, and that's also where research will probably be moving into the next few years, is the question, and it's really an unsettled question, of what's the relationship between the Second Convention and the wide variety of treaties that have been adopted, most prominently under the auspices of the International Maritime Organization, a UN specialized agency based in London, by virtue of which states have committed themselves to quite far-reaching obligations when it comes to rescuing individuals in distress at sea, and a legal requirement to have to deliver these people to a place of safety. The question is, do these treaties continue to apply in times of armed conflict or not? Most of the treaties remain silent on the question. There's, contrary to human rights law, no derogation clause in these treaties, but the question obviously becomes, have they been drafted only with peacetime scenarios in mind, or are they going to be able to be invoked also in time of armed conflict? The only thing we have done on that particular point in our introduction is identify the problem, because this is not something states have been thinking about themselves. It's obviously something now scholars have started to look into, because we identified this as a very interesting question. The only thing we've done is to suggest, but again, state practice will be there to confirm or to deny the validity of this reasoning, is to distinguish first and foremost the relationship between the parties to the armed conflict, where most likely the legal framework that will be most guiding will be the law of armed conflict, which already takes into account the military necessity, the operational constraints flowing from the armed conflict. However, when it comes to the relationship between neutrals, so states that are not a party to the convention versus the parties to the conflict, you cannot just simply invoke the existence of an armed conflict to remove the applicability of these conventions, most prominently the Safety of Life at Sea Convention and the Maritime Search and Rescue Convention. However, probably the closer you get in physical, geographic terms to the zone of hostilities, the more likely it is that you're going to run into the argument that the legal framework regulating these activities is exclusively international humanitarian law, not the commitments states have undertaken on the basis of these conventions. With that, I'll hand it back over to Ann-Harriet and open the floor for further questions. Thank you very much.
Excellent, and thank you very much, Bruno. A very clear presentation on indeed perhaps a technical topic, but I think very much of interest to everyone who is here. So thanks so much for taking the time to be with us today for this briefing. We've had actually quite a few questions come in. Before I turn to the first set of questions, I do want to just highlight, as we did have the polls visible during the event, we've actually we have quite a few people in this virtual room who have already been using the updated commentary from the ICRC on the first Geneva Convention. No one yet using the commentary on the second, but perhaps looking forward to do that, as I see there are a few people now answering polls who have been working in humanitarian operations at sea. But moving to our first question, we had an interesting one come in just a couple of minutes ago from Elizabeth, and I'll read it out to you, Bruno. It's regarding potentially a wider scope of application of GC2. So Elizabeth writes, I find the interpretation leading to a wider scope of application of the Second Geneva Convention interesting and relevant in terms of enhancing protection. To the extent that AP1 applies to international armed conflict, I wonder how is the argument supported in relation to non-international armed conflict, whereas probably more likely to find situations where lakes or rivers, as you mentioned, might come into play.
That's a truly excellent question. So to resituate the issue is that in terms of scope of applicability, geographic scope of applicability, the second convention's title speaks of sea without defining the concepts. Under Additional Protocol 1, Article 8b, for the purposes of the protocol, states have agreed to a definition of who's to be considered a shipwrecked, where the geographic scope of application referred to is that of being at sea or in other bodies of water, which for us was, as far as international armed conflict is concerned, was the ground on which to stand, and also the protection rationale, the compelling protection rationale to indicate that the legal status of the water is immaterial. Now, on the specific question of how do you deal with this question when it comes to a non-international armed conflict, I would not be too hesitant to indicate that as a matter of customary international law, the definition of Article 8b, shipwrecked, can be considered to be equally applicable and relevant both in international and non-international armed conflict. For this very same reason, the protection needs of a person in a non-international armed conflict who's shipwrecked on a lake are going to be 100% identical to the protection needs of a soldier who's shipwrecked on the high seas. So I would not hesitate from a protection perspective, and I'd be surprised if there be pushback against that notion that we indicate that shipwrecked is any body of water, any type of water, regardless of the legal qualification. In our commentaries, for those interested in the issue, in our commentary on Article 12, we grapple with the opposite way of arguing, which has also been arguing to us by some of our peer reviewers, where basically you would observe to say sea is saltwater sea, but then you run into the difficulty that you would need to apply the first Geneva Convention, which doesn't contain a notion of shipwrecked. And shipwrecked is obviously the one legal label that is relevant for people who are not wounded and sick, yet who are in need of protection because of their being in the water.
Okay, excellent. Thank you very much. We now have a question coming in from Ayuk, based in Cameroon, and he is asking, what are the main differences, or how could you sum up the main differences under IHL between the protection conferred to wounded and sick on land versus protection conferred to them at sea?
Well, I would say there's only one textual difference, and that's the fact that the second convention, including in Common Article 3, adds the word shipwrecked. By and large, protection for members of the armed forces who are wounded and sick or shipwrecked, whether on land or at sea, the very same rules and principles apply. They have to be respected and protected, and all possible measures need to be taken to rescue them. As a matter of fact, during the negotiation of the Geneva Conventions, at some point there were proposals to merge what is nowadays Convention 1 and 2, exactly based upon the argument that where the protection need arises, whether on land or at sea, is immaterial. It's the same reflex we need to have. That proposal didn't make it for the reasons invoked at the time, that most likely commanders of naval operations would be more familiar with the second convention, not with the first, and the other way around. But as such, there's no different, it's the same principles.
Okay, great, thank you. And now this next question, you did address it to some extent in your presentation, but it's an important question, so maybe worth coming back to. Again, this is a question from Enrique, who's based in Venezuela, asking, is it possible to apply the protection conferred to medical personnel by the Second Geneva Convention in other humanitarian contexts away from an armed conflict zone? So, for example, medical personnel helping migrants crossing the sea.
That's an excellent question, and it deals with one of the notions where, for reasons of time, I wasn't able to focus on. So as far as international armed conflicts are concerned, both in Conventions 1 and 2, there is protection of medical personnel. In those conventions, however, it's about the protection of military medical personnel. So members of the armed forces who are not combatants, yet we do have a role to look after the medical needs of the combatants. In the second convention, this is dealt with in Articles 36 and 37. which deal with the legal status of medical personnel serving on board hospital ships, respectively other categories of vessels. And in the third convention, the first Geneva Convention, Articles 24 and following, we also have rules regulating the legal status of medical personnel, military medical personnel. Now, the specific question was protection of medical personnel outside these type of situation. And there, obviously, when it comes to individuals looking after the medical needs of the civilian population, the fourth Geneva Convention also contains rules regulating the protection of civilian medical personnel. But there is an important point to keep in mind on this particular question. When the Geneva Conventions speak of medical personnel, there's various requirements that have to be met in terms of the state, the party to the conflict, giving these people an assignment to serve on certain medical duties, as well as a requirement that these individuals exclusively act in a medical capacity. And this is a construct which is inherent to international humanitarian law, by virtue of which the parties to the conflict retain quite a significant degree of control in terms of who qualifies as medical personnel in the technical sense of the convention. In other words, and this debate was quite prominent over the last few years, you will observe in time of armed conflict certain individuals, we could refer to them as healthcare workers or medical workers, who are going to be carrying out medical activities, whether for combatants or whether for civilians, without qualifying in the technical sense as being medical personnel that are entitled to the special or so-called specific protection under the convention. Now, this does not matter. It matters that you are medical personnel in the sense of the Geneva Convention, because from that label flows an entitlement to display and to use the distinctive emblem of the Red Cross or Red Crescent or Red Crystal. This is an entitlement that individuals who are performing medical activities without being technically meeting the requirements of being medical personnel, this entitlement is not conferred to them. At the same time, despite their not being entitled to the label of the special protection of medical personnel, in any event, to the extent that they don't participate in hostilities, these individuals will be and have to be treated as civilians that are to be respected as such.
Okay, great, thanks. So we have a question that's just come in from Ramsey, based in Syria, and it's a question of clarification regarding the responsibility to search for and collect wounded and shipwrecked. He writes, the main focus of the debate seems to assume that anyone is shipwrecked by attack from a waterborne vessel, a ship, boat, or submarine, but he wonders who bears the responsibility for searching for and collecting wounded and shipwrecked as a result of attack by land-based missiles?
Excellent question. So we need to answer this, we really need to go back to my final slide, which was, on the one hand, we have the obligations flowing from international humanitarian law. On the other hand, we have obligations flowing from other bodies of international law. Now, under the Second Geneva Convention, the obligation to search for and collect casualties as well as the deaths that are the direct result of the military engagement, that obligation only applies to the parties to the conflict, regardless of how these people became casualties. So the particular question referred to a missile that has been fired from land. To the extent the casualties meet the personal scope of application criteria to qualify as shipwrecked in the sense of the second convention, it's the legal obligation of the parties to the conflict to take all possible measures to search for and collect them. Now, the distinction there is on the basis of Article 21. The parties to the conflict have the entitlement to call for help to neutral vessels, to ask neutral vessels, so of states or registered in states that are not a party to the conflict, to come to the rescue of these casualties. Now, as a matter of international humanitarian law, these neutral vessels have no legal obligation to respond positively to that request for help. And this is exactly where bodies of international law outside of IHL are so relevant, because under the UN Convention on the Law of the Sea, the Safety of Life at Sea Convention, as well as the Maritime Search and Rescue Convention, and a number of others I could enumerate, there is an obligation, it's not an absolute obligation, for all masters of vessels to rescue people in distress at sea. And this is a norm of customary international law, a norm that is also widely accepted in the maritime as well as shipping industry. So on that legal basis, they may have a legal obligation to search and rescue the casualties of the engagement. But as I indicated, it's not an absolute obligation, because your own security may be a factor that can be lawfully invoked in order to argue why it's in the present circumstances not possible to carry out these search and rescue activities.
Okay, thank you very much. Here we have a question. So this is coming from Richard in Cameroon. So you had mentioned in your presentation that it is harder to monitor naval warfare. So Richard is asking, do you think that as a result of that, that currently the Second Geneva Convention is actually less respected on the battlefield than other conventions, given that it's harder to monitor naval warfare?
Well, first, I would let's distinguish the facts from the law. The facts is that to the extent we are going to see in the future armed conflicts at sea, it is quite likely that the parties to the conflict themselves will declare so-called exclusion zones, no-fly zones, no sail zones, whatever they are or may be called, and that the shipping themselves, the commercial shipping that otherwise would be passing through the area in which the hostilities are taking place, will out of their own initiative actively seek to avoid that they have to get anywhere close to the zone where the hostilities and therefore the danger. Starting point is yes. In case of an armed conflict at sea, it's much more unlikely that independent civil society or other monitors are going to be able to assess what is actually going on the ground at sea in this particular case. Now, does that mean that the convention is less respected? I would say is a different question. It obviously depends contrary to, for example, instances of urban warfare where civil society is immediately able to monitor, record, and report certain violations of IHL. I think it's true. As a matter of fact, this is much more unlikely that this is going to happen in real life in case of an armed conflict at sea. At the same time, this puts the burden of compliance on the armed forces commanders themselves to, in good faith, assess what are the measures that we possibly can undertake and therefore legally are required to undertake.
Okay, great, thanks. So here are a pair of questions. I'll pose them together. So first, from George, who's based in the United States, he's asking, are there any specific law enforcement mechanisms to enforce IHL at sea? And then I'll pose another question. This is from Abdurrahman, based in Kenya, asking, is there any recent applicable case law when it comes to the Second Geneva Convention?
Okay, so we need, in terms of terminology, we need to distinguish between maritime law enforcement versus armed conflict. So maritime law enforcement are the wide variety of peacetime measures states undertake in order to enforce their domestic security, fisheries, or whatever type of legislation at sea. Now, maritime law enforcement is not armed conflict, and the distinction I dwelled upon to some extent has particular relevance when it comes to the legal framework regulating the standards for the use of force, which are very different in case of maritime law enforcement, where the standards for the use of force are much more akin to human rights law as compared to an armed conflict situation in which we will have a conduct of hostilities paradigm. Now, the question goes to the question of what are the enforcement options when it comes to the Second Geneva Convention. There's not much difference between this convention and the others in terms of if you have, and there have been after the Second World War, a number of criminal trials that were related to those type of allegations. If, say, a commander instructs the troops under his command to shoot all shipwrecked, or to shoot all wounded and sick at sea, this is a very clear war crime, as it would be on land. So that's clearly an enforcement option, with obviously the difficulty about how to collect evidence in case not many independent observers were present. Were clearly both the Achilles heel as well as I would say the potential for criminal enforcement of the second convention lies is Article 18. Because as I said, this provision, applies to the parties to the conflict, but at the same time, it is possible to argue on the basis of the Rome Statute of the International Criminal Court that in certain circumstances, deliberate forms of non-compliance with Article 18 may qualify as the war crime of willful killing by omission. So a commander who would instruct the troops under his or her command, no matter what, not to rescue any survivors, this may, obviously depending on the circumstances, meet the constitutive elements of that particular war crime. On the second question, have there been any instances of recent case law? When it comes to the second Geneva Convention, not that we are aware of. There have been cases the last few years dealing with a lot of law of the sea aspects, but we as ICRC obviously don't take any position when it comes to, say, territorial claims or to, say, release of certain types of vessels. There have, however, been in a number of conflicts, not many admittedly, but there have been in a number of conflicts since the Second World War, demonstrations of both the applicability and the relevance of the Second Geneva Convention. The most prominent example, which we deal with to some extent in the commentary, is an international conflict that was fought in 1982 between the United Kingdom and Argentina with regard to the Falklands/Malvinas. We as ICRC refer to both denominations in alphabetical order, but that conflict pertaining to the Falklands/Malvinas Islands in the southern part of the Atlantic Ocean was a conflict in which the Second Convention applied and in which a great number of its provisions were resorted to in actual practice.
Very interesting. Thank you. Now we have a question of clarification. This is coming from Joanne, based in the US. She is asking whether or not or how does the Second Geneva Convention ever apply to the rescue of refugees on the high seas? Is it ever the case?
So that excellent question, because it's one which is critical, I think, from a practical perspective for humanitarian professionals, is really the question of, is this refugee migrant, it's not our job from an IHL perspective to answer that question of the person's status in terms of refugee law. Is this person a person who qualifies as being wounded, sick, or shipwrecked in the sense of international humanitarian law? And so as far as the second convention is concerned, personal scope of application, that convention only protects members of the armed forces, not civilians. The only exception to that, obviously, being Common Article 3, which protects members of the armed forces, members of the organized armed group that is a party to the armed conflict, as well as civilians that are shipwrecked. But there is the critical qualitative distinction that it only protects those that are shipwrecked as a direct result of hostilities in case of a non-international armed conflict. So yes, migrants may be shipwrecked in the sense of international humanitarian law, but only to the extent their being shipwrecked is the result of the hostility. So those who are shipwrecked because the vessel in which they were seated was actually incapable of transporting them properly and the vessel therefore sinks, are not shipwrecked in the sense of international humanitarian law, but what we continuously need to emphasize as humanitarian practitioners, and our commentary does so, is that obviously they are most likely going to be protected on the basis of other rules of international law.
Excellent, thanks. And now our final question, a great one to end with. This is again from Abdurrahman, based in Kenya, asking, do you actually foresee any instances of war at sea between countries in this modern period of civilization? Is this something that in reality you would expect to see in the near future?
Well, obviously, we as ICRC neither want nor encourage armed conflict. We just observe the activities states undertaken and remind states of the rules that are applicable to the activities they either deliberately or against their will find themselves in an armed conflict at sea. So it's not up to us, I think, to answer that question. What I would observe, however, is that to the extent we will see that all of a sudden navies of big naval powers are engaged of an armed conflict at sea. This, to me personally, speaking in my private capacity, means that most likely there will have been a premeditated political decision taking at the highest level of the states to engage in an armed conflict. And obviously, one of the topics we as ICSC don't deal with is the so-called jus ad bellum, the law regulating the legality of the recourse to force. We, as ICRC, only deals with the rules that are applicable once there is a recourse to force. Now, where this is, I think, something to monitor in certain parts of the world is the role not so much of navies, but the role of coast guards. Because coast guards in certain countries are involved in the enforcement of certain jurisdictional rights or the enforcement of certain claims. And this is the very aspect where we've monitored the last few years a couple of instances in which coast guards of two states have been involved in a standoff situation, and where this question, this very difficult and partially unsettled question as a matter of international law, comes to the forefront, to the extent that international humanitarian law only applies to an armed conflict, and we continue to emphasize that what matters are the facts on the ground. The question that will need to be answered in these violent incidents is, have we crossed the threshold of an armed conflict or not?
Very good. So we're coming now to the end of our time, and I would like to, Bruno, give you the floor once more for any concluding remarks that you would like to share with us, perhaps regarding the next steps for the project, for the updating of the commentaries, or any important discussions that you see coming up in the future related to your work.
Thanks, Anharat, for that opportunity. First and foremost, when it comes to the second Geneva Convention, the response received worldwide has been very encouraging, in particular from navies from around the world, exactly because of this point that I made at the beginning, that everybody, including IHL experts, knew that the second convention was there, yet nobody had really looked at it in great detail. And clearly one of the advantages we've observed since publications is that navies around the world are looking at our commentary and are seriously studying the implications this may have for them in terms of having a more sophisticated understanding of their rights and obligations when it comes to protection considerations in warfare at sea. Now, moving forward, obviously, the project goes more to a land-based scenario, looking into the third convention, which we hope to publish in about 2 years from now, where the number of fascinating questions that my colleagues and I are currently dealing with is endless. But for that, obviously, I need to beg for some patience because we're beyond the early stages of drafting, but there's some more work to be done before we are able to publish the commentary on that convention.
Okay, very good. Well, thank you again so much, and really congratulations to yourself and to all of your colleagues for the impressive work. I'm sure that we're all looking forward to 2 years from now for the next briefing on the third Geneva Convention. But in the meantime, all the best with the ongoing discussions that I know are still underway following the publication of the commentary on the second. So to all of our participants, thank you so much for your participation. There were some excellent questions that came through, so a very interesting discussion. Both the audio and video recordings and all of the resources that have been mentioned in lead up to the event will be available in the next few days. Those will be available on the event webpage, and you can see the link there on the screen. That will also be emailed around to everyone who registered for the event, so you can access that as an ongoing resource. So thank you once again also to my colleagues here at PHAP, to Marcus and Liz for their great work behind the scenes making this possible. And then finally, last but not least, one last thank you to Bruno de Meyer for his presentation and for his help in making this expert briefing available to a global audience. It's very exciting and we're very pleased to have had the opportunity to host it. So then until next time, this is Anne Lang and the rest of the team at PHAP signing off.